just to pick up where I left off, the hearing to which Mrs. Chirwa was called to on the second occasion did not sit well with Mrs. Chirwa on the basis that Mr. Smith was not only the complainant, she had also lodged a grievance against him, which had thus far not been resolved, but he was also the presiding officer. So she refused to attend the disciplinary hearing, and it took place in her absence. And Mr. Smith then concluded that she should be dismissed. Pursuant to the hearing that took place in her absence, a letter of dismissal dated the 22nd of November 2002 was issued to Petronella Chirwa, advising her that she could exercise her rights in terms of the Labour Relations Act, and it was signed by Mr. Smith as CEO of the business unit, i.e. the second respondent. Following her dismissal, Petronella Chirwa referred a dispute to the CCMA, alleging that her dispute had been procedurally and substantively unfair, and it went to conciliation. And at conciliation, the conciliation failed, resulting in the commissioner at the CCMA issuing what's known as a Form 712, which is a certificate of non-resolution of outcome of dispute referred to conciliation, which now entitled Mrs. Chirwa to proceed to compulsory arbitration against Transnet. However, instead of going to compulsory arbitration, Petronella Chirwa decided instead to go to the High Court, where she sought an order setting aside the disciplinary proceedings resulting in her dismissal and also asking to be reinstated. Her complaint at the High Court, or her pleadings, were based on the fact that she essentially raised a claim under the Labour Relations Act. It was a bifurcated claim. Firstly, it flowed from Section 33 of the Constitution as read with Padra, because of the fact that she was a public sector employee who had been dismissed. And secondly, her rights in terms of Section 23 of the Constitution, her right to fair labour practices, had been impugned by her employer. So it's on that basis that she took the matter to the High Court, and she alleged that the disciplinary proceedings were flawed on the basis that Mr. Smith, who was her accuser, was also the presiding officer, and the person against whom she had lodged a formal grievance, which had as yet not been resolved. The question that the court was called upon to decide was whether the claim as raised by Petronella Chirwa conferred jurisdiction on the High Court or the Labour Court. In other words, there were two causes of action arising from her dismissal: her right to fair labour practices in terms of Section 23, and her right to just administrative action in terms of Section 33 of the Constitution. The High Court did the following. It merely assumed it had jurisdiction to hear her claim, but it never reached a conclusion based on the violation of the provisions of Padra as pleaded by Chirwa. Now, it's important to bear in mind that Petronella Chirwa actually pleaded her case on the basis of Padra, her right to just administrative action. The High Court based its decision on the common law rules of natural justice with reference to the 1991 Appellate Division, as it was then known, case of Administrator Transvaal versus Zenzile, where Hoekster J.A. found that the dismissal of a public sector employee was not simply a matter of a termination of a contractual relationship, but rather the exercise of a public power, which meant that the employer had to apply natural justice rules. The High Court declared Chirwa's dismissal a nullity and ordered her reinstatement on terms no less favorable than they were at the time of her dismissal on the 22nd of November. Now, it's important to take the following into account, and this is where the rub of this case appears. If you read paragraph 23 of the judgment, which is penned on behalf of the majority by Squia J, Squia says the following at paragraph 23. To the extent that the High Court did not consider Chirwa's claim in the context of Paja, it erred. Just remember that. The cause of action of what is claimed to be an administrative act now arises from Paja and not the common law. And in this regard, Squia relies on the authority of paragraph 25 of Barter Star. So at the outset of the judgment, Squia recognizes the importance of, if you are going to ask for judicial review of administrative action, you have to rely on Paja. I'm going to repeat that. At paragraph 23 of the judgment, Squia says, to the extent that the High Court did not consider Chirwa's claim in the context of Paja, it erred. Now remember that, because as we go through the judgment, we'll see that the Concord contradicts itself in its reasoning and the way in the manner it approaches the claim before the Constitutional Court. So the dictum to which I've just referred to at paragraph 23 purports to establish the manner in which the Concord will now be assessing Petronella Chirwa's claim, i.e. in the context of Paja. At least that's the assumption we make. But we're wrong in making that assumption, as I'll show you shortly. So with Petronella Chirwa having succeeded at the High Court, Transnet took it on appeal to the Supreme Court of Appeal, where the following happened. Matanyana and Jafta, judges of appeal, held that the High Court has concurrent jurisdiction together with the Labour Court to entertain Chirwa's claim. They essentially held that if in an employment relationship there arises a dispute pertaining to certain constitutional rights, it might be a labor-related right or it might be a just administrative right, it means that that employee is entitled to remedies that the High Court can give. In other words, the High Court jurisdiction is not ousted. The employee is not confined to merely going to the Labour Court in order to seek relief. And in support of this reasoning, the Matanyane and Jafta relies on the 2002 Constitutional Court case of Fredericks versus MEC for Education and Training, Eastern Cape, which held that Labour courts are not afforded a general jurisdiction in respect of employment matters, and that High Court's jurisdiction is not ousted by Section 1571 because a dispute arose in the employment sphere. This was also relied upon in the FedLife Assurance versus Wolfart matter of 2002, which is an SCA decision, as well as the De Gomo case, a 2005 decision of the SCA. I might just, at this point in time, point out that the provisions of Section 1571 and 1572 of the Labour Relations Act are important to take into account, because essentially what Section 1571 of the LRA provides is that the Labour Court has exclusive jurisdiction in respect of all matters arising from the employment relationship. I'm merely paraphrasing the statutory provision. However, Section 1572 says that the Labour Court enjoys concurrent jurisdiction with the High Court in respect of any violation of rights in Chapter 2 of the Bill of Rights, that even if such violation arises from the employment relationship. Okay, so sub 1 gives exclusive jurisdiction to the Labour Court, but sub 2 gives concurrent jurisdiction to the Labour Court and the High Court. So that's the finding of Matinyana and Jafta. They find that the Labour Court does not have exclusive jurisdiction, that where you have two causes of action arising out of one set of facts, you cannot say that the jurisdiction of the High Court is ousted or excluded. But Matinyana and Jafta go further. They conclude that Chirwa's case has to fail in terms of showing that her dismissal constituted administrative action. And why do they find this? They find this on the basis that her dismissal came about, her termination was the result not because of a legislative provision or an empowering provision, but it was because her termination took place in terms of a contract. You'll remember that the contract, her letter of termination dated the 22nd of November, was in terms of a contract. It wasn't in terms of any statutory provision. So on that basis, her claim before Matinyana and Jafta failed because the termination was contractually based and not statutorily based, and therefore did not amount to administrative action. Conradi was the third judge in the SCA who accepted without deciding that Chirwa's dismissal did in fact constitute administrative action, taking into account the nature of power that Transnet exercises and its public function and so forth. However, he found that since the advent of the Labour Relations Act, all employees, private sector or public sector employees, all fall under the umbrella of the Labour Relations Act, and therefore the Labour Court enjoys exclusive jurisdiction over such dismissals, and that Petronella Chirwa should have exhausted her remedies under the Labour Relations Act. And it's true to say that the LRA does provide for the review of certain matters. In this regard, you can have a look at Section 1581H of the Labour Relations Act, as well as Section 145 of the Labour Relations Act. So that was Conradi's finding. Cameron, J.A. and Lexham Party, Judge President or Deputy Judge President of the SCA, dissented. They both found that they upheld the findings of the High Court, namely that Petronella Chirwa's conduct or the factors surrounding her dismissal gave rise to two causes of action, one in labour law and one in administrative law. And they said that neither the LRA nor PAJA expressly excludes the jurisdiction of the High Court or any other court for that matter, and the existence of the LRA does not prevent an employee such as Chirwa from actually pressing her claims under PAJA. And furthermore, they concluded that public sector dismissals could constitute administrative action. Although Petronella Chirwa's dismissal took place in terms of a contract, if you look at the statutory nature and provisions regulating the conduct of the respondents, namely Transnet and its business unit, its the second respondent, there was no doubt in their minds that her dismissal constituted administrative action. However, it's important to take into account that the SCA judgment makes no definitive finding on whether the conduct by the employer should be reviewed under PAJA. and this is the reason for this is that Matinyana and Jafta found Petronella Chirwa's termination on the basis of a contract not to constitute administrative action. Conradi, on the other hand, found Chirwa's dismissal to constitute administrative action, but that she was in the wrong forum. She had to use the exclusive jurisdiction of the Labour Court, and Cameron and Lex Party agreed with Chirwa that she was allowed to use the forum of the High Court as opposed to being compelled to use the forum of the Labour Court. So Chirwa was then left with no choice but to take her matter on appeal to the Constitutional Court. And from the outset, when one reads the Constitutional Court's judgment, it's important to note that there's an inclination or a leaning in favor of an interpretation that favors the LRA as opposed to PUDGA or as opposed to administrative action. In other words, if one looks at Square's reasoning, one can scheme from the reasoning that Petronella Chirwa, after her dismissal, should have exhausted all her remedies under the LRA and not have gone to the High Court. So at paragraph 40, Square says all employees, including state employees, are now protected by the Labour Relations Act. Because before the coming into operation of the LRA in 1995, public sector employees were governed by the Public Service Act and various other legislative provisions. That is now no longer the case. And Square goes further to say that it is unsatisfactory that the High Court should be approached to decide a review application in terms of PUDGA where the LRA already provides such remedies. Remember, previously I referred to Section 158 and Section 145 of the LRA. And in this regard, Square also refers to Cameron's remark in the judgment of the SCA, where Cameron in an obiter remark says, the ordinary courts must be careful not to usurp the skills and expertise of the Labour Court. Square goes on to refer to the existence of the purpose-built framework in the form of the LRA, which shows that it should take preference over non-purpose-built processes involving employment-related matters. So, and he goes on to say that the LRA includes principles of natural justice. It has dual fairness dealing with substantive and procedural justice. And judicial review of administrative action decisions can only result in a decision being set aside, but does not prevent an employer from starting the process over again. In other words, what Square is arguing or trying to articulate is that the LRA provides employees much greater protection than they would ever, than the protection could be afforded them in terms of PUDGA. The question before the Constitutional Court is, because there's been a dismissal of a public sector employee which implicates a labour right and an administrative justice right, both of these rights are entrenched in the Bill of Rights, each with its own objectives and its effects in terms of specific legislation. The question is, which forum does a public sector employee approach? And Square says that both rights, in other words, your right to fair labor practices and your right to just administrative action, both rights are regulated by specialized legislation. And this was emphasized by the Labour Court in the SAPU versus National Commissioner of SAPS, a 2006 Labour Court decision. Square goes further to say that the aim of administrative justice is to bring about procedural fairness in dealings between administrators and members of the public. In this regard, he refers to the New Clicks case, and he draws a comparison between that aim of admin justice with the aim of labor law, which is embodied in the Labour Relations Act as to provide a comprehensive system of dispute resolution mechanisms, forums, and remedies tailored in all aspects and respects to meet the employment requirements of employees and employers. It is envisaged, so Square says, as a one-stop shop for all labour-related disputes. Moreover, Square points out that the explanatory memorandum on the Labour Relations Bill 1995 refers to the Labour Relations Act as a product of extensive process of negotiation between all affected stakeholders. This was business, labour, and government. And an express aim of the Labour Relations Bill was to address the lack of overall integrated legislative framework for regulating labour relations and issues arising from a multiplicity of laws governing different sectors, namely the private and the public sector. Hence, the bill aimed to eradicate inconsistencies, unnecessary complexities, and dual jurisprudences or dual jurisdictional confusions arising. Interestingly, Square points to the provisions of Section 210 of the Labour Relations Act, which provides that in the event of there being any conflict between the Labour Relations Act other than the Constitution, which is the supreme law, that the Labour Relations Act will prevail. So Section 210 heralds the Labour Relations Act as the inimitable or incomparable legislation that must take preference over PAJA. Now remember that the Labour Relations Act came into effect in 1995. PAJA only came into effect 30th of November 2000, 5 years later. And nowhere in PAJA does it refer to the fact that you are allowed to bypass Section 210 of the Labour Relations Act, or since PAJA came into operation, Section 210 of the Labour Relations Act was never amended. I'm just going to, we're already on 23 minutes on this second video. I'm going to stop this video and then start with the third one.